All right. Well, good evening, everybody. Thank you for joining us tonight. My name is Troy McIntosh. I serve as the Executive Director of the Ohio Christian Education Network. We're joined as another panelist with Corinne Vidalis. Corinne serves as the OSEN Legal Counsel and also our OSEN SGO Director. So if any of you have either given or received a scholarship through the SGO, you may have interacted with her at some point. So we are so glad you're here tonight. Just to tell you a little bit about who we are, the Ohio Christian Education Network is an association of 210 Christian schools across Ohio. And we do a number of things on their behalf. Primarily, we do public policy advocacy. So Corinne and I are both lobbyists. You can see right behind me, we're right across the street from the Ohio State House. And so we are there on a regular basis advocating for public policy that fairly and equally deals with, provides for Christian schools. And so we are excited to do that role and serve in that regard. The goal tonight is to give families that are benefiting from the EdChoice scholarship a better understanding of the current context of the lawsuit that is currently pending in appeals court in the state, and really to try to ease some of the anxiety that we sense is building among school families that are making use of the EdChoice scholarship. So what we'll do is I'm going to start by giving a kind of a broad overview of the issue and why we believe that there is no reason to be concerned at this point. I'll turn it over to Corinne, and Corinne, as the legal expert on our staff, will give you an overview of the case and where it currently stands in courts. And then I'll come back and provide some talking points and action points for everybody to take away tonight. So that's kind of the big overview. We'll have a chance for questions at the end. You can either drop them into the Q&A chat that's at your toolbar at the bottom of your box, or at the end you should be able to allow your microphone and you can ask a question in person as well. So again, thanks for joining us. Let's get started. Many of you have familiarity with the EdChoice program. The EdChoice program originated all the way back. The origins of EdChoice came out of a 1996 program called the Cleveland Scholarship Program. That program was enacted by the Ohio General Assembly and signed by the governor in order to provide scholarships to students who exclusively lived in the Cleveland Municipal School District. That was a poorly performing district at the time, and the state provided scholarships so that students living in that district could attend private schools of their choice. That program was expanded outside of the boundaries of Cleveland in 2005 and was called the EdChoice Scholarship Program. That system operated pretty much with some expansions, some changes for 18 years until in 2023, the General Assembly authorized a universal expansion of the EdChoice program in which every student living in the state became eligible for an EdChoice scholarship. We were the lead advocates for that bill. We actually helped draft, along with Representatives McLean and John, the backpack bill, if you're familiar with that. Corinne, we can date that all the way back to a coffee shop meeting that we had with Representatives John and McLean back in 2021 up in Upper Sandusky. And that backpack bill eventually became the EdChoice expansion that occurred in the state operating budget in 2023. Hopefully, all of you are taking advantage of that scholarship now. Of course, what we expected when we went to a universal expansion was a significant pushback from the public school community and what we might call the educational establishment. And that's exactly what we received shortly after. Well, actually, it was just before the EdChoice expansion, the universal expansion. a coalition of public schools operating under the name of the Coalition for Adequacy and Equity, filed lawsuit against the state claiming that the EdChoice program was unconstitutional. And that claim was made on state constitutional grounds, not on federal constitutional grounds. Corinne could probably address that a little more better than I would. But that took place in 2022. Many of you know recently that it was, you probably heard that a Franklin County court ruled the program unconstitutional. What I would like to do, first of all, is give you some ideas on why that should not induce panic in you or concern that the program is going away. Okay, several things reasons why we don't want you to fear and fret over this issue right now. The first one is the EdChoice program has been established for over 20 years, and that sets a significant legislative precedent for the program. So the weight of that existence will play a role in whatever ongoing court, whatever final court decision that there is. That's a significant thing. There have been a few states where the state Supreme Court has ruled similar, although not identical, programs unconstitutional over the last several years, but those were all very new programs, typically only hadn't even been established yet or in their first or second year of operation. So the fact that the EdChoice program has been around for over 20 years is a significant plus in the defense of the program. Secondly, the Ohio General Assembly is strongly pro-choice right now. The mere fact that they made Ohio just the 13th state to have a universal school choice program says a lot. The leadership in both chambers is strongly pro-choice. The vast majority of membership is pro-choice. So these were not pieces of legislation that just barely got through the General Assembly. The universal expansion passed with almost a supermajority of votes in favor of it. And that says quite a bit, particularly if the General Assembly needs to go back and make some kind of minor changes to the program in order to satisfy some kind of court's concerns. The third thing is that Attorney General Yost will vigorously defend the program. As a matter of fact, he is a significant supporter of school choice programs, EdChoice in particular, and he is the person who is charged with defending the state's position on this. And it is his intent to take this as far as necessary in order to secure the lasting permanence of the program. And then finally, the Ohio Supreme Court, and Corinne will talk about this in a little more detail in just a minute, currently has an 8-1 conservative majority. And why that matters and is significant is conservative justices, just like conservative lawmakers, tend to be more open to school choice than lower courts. Now, no Supreme Court justice or judge of any sort is going to come out and tell you how they are going to rule on a particular case that may or may not be coming before them. So it's not like we have a straw poll of Supreme Court justices, but we feel fairly confident with a majority of that amount that when this case reaches the Supreme Court, it will be much more favorably heard than the lower courts. Keep in mind, the reason that the coalition filed suit in Franklin County is because they believed Franklin County judges were the most likely county judges to overturn the program. So Franklin County tends to have progressive liberal justices. They found one, they filed suit in her court. So it was no surprise that Judge Page overturned the program. It's also no surprise that they knew the appeal would be made to the Franklin County, the 10th District Appeals Court, because that is overwhelmingly staffed, again, by liberal judges who would look less favorably on the program. So Corinne will walk you through that process now. Corinne, why don't I turn it over to you and you can share kind of the background of the program and where we're at.
Yeah, so we're gonna get in a little bit more into the nitty-gritty of what the Supreme or what the kind of the trial court decided. So to start, the plaintiffs are, like Troy mentioned, they're a coalition of public schools. Columbus City School, that's the named one. It's just the first name. So it's a coalition public school, a couple of public school students, and then a few individual public schools on their own behalf, both as part of the coalition and then separately. And those are the plaintiffs. And then the state is the defendant. So that's Attorney General Yost that's defending this. So they originally filed, like Troy said, Franklin County Common Police Court, and that they were sure to find a Democrat judge there who was going to be slightly less school choice friendly. So when they did that, they had five main arguments that they presented, and they technically won three out of the five, but the two that they lost on were not exactly that important as far as that choice goes. Um, so to start with, all of these, like Troy mentioned, are state constitutional claims, with the exception of the third one that brings in some 14th Amendment federal Constitution issues. But that was the one that they lost, and that third one, you'll see my third bullet point there. We'll get to in a second. I can explain a little bit more. So the first one, under the Ohio Constitution, the General Assembly is charged with the creation of one or more systems of common school, is charged with the creation of a system of common schools and has to be a thorough and efficient system of common schools. So the claim here by the plaintiffs, the public schools, was that this system, because of EdChoice, was not a system of common schools. It was uncommon in that there was two court systems. So Judge Page ruled in their favor. She said that she thought that that was true based on the evidence there that they presented. The second one that was also granted was that same clause in the Ohio Constitution was that the General Assembly failed to secure a thorough and efficient system of common schools. And this had to do primarily with the school funding formulas that are in the budget passed by the General Assembly. They said that essentially by awarding scholarship money to families, they were not securing a thorough and efficient system because the public schools were not being properly funded. Most of you are probably aware, and Troy's going to get to this in some talking points later, is that the public schools are funded separately from the EdChoice program. So while this point was granted in favor of the public schools, we'll get to later. None of these we would agree with, and you'll see the Supreme Court we believe will agree with us. The third point that was denied, and this is where those 14th Amendment claims come in a little bit, is the segregation in violation of the thorough and efficient system of common schools. So essentially here, the plaintiffs were arguing that the EdChoice scholarships allowed created segregation within the schools, that there was a lot of wealthy white kids who were able to take advantage of this, and that was creating segregation between black families and white families, which we actually have research that proves the opposite. So Judge Page, she denied this for the plaintiff, so she said that she didn't find any evidence to prove that was true. She also denied this for the defendants as well. Basically, she just said there's no evidence here that shows any kind of segregation, either for or to prove that, segregation is not happening. She said nobody presented any evidence to show anything about segregation one way or the other. So both parties' claims were denied here. The fourth claim then was that there's an unconstitutional state funding of religious schools. So this is a little bit different portion of the Ohio Constitution that says no religious sects shall take any part of school funding for themselves. Essentially, it's saying that, no, there should be no money flowing to religious schools whatsoever. And she granted this. She said it's very obvious that schools are receiving money from the state. Most of you are probably aware the money is yours as families and EdChoice recipients. However, because the money is flowing to the public schools or to the private schools in your name, she felt that that showed a unconstitutional state funding of religious schools. And then finally, the fifth part here, which the plaintiff's claim was also denied, was essentially just saying this was specifically on behalf of those two public school students that sued as themselves and not as part of their school to say that they were being unfairly funded compared to the private school students. So they said that this state was only awarding them $1,500, $2,100 in state funding for their public school, while their similarly situated private school students in the same district were being given $6,000 or $8,000 from the EdChoice scholarship. So Judge Page also denied this one because it was only those two students, and so they couldn't really show that all students were affected that way, and they didn't have a good grasp of what the funding really looked like. So that's kind of the rundown of the official claims that were made in the case. The one thing to note here is that the um, the trial court is typically where you will see, if you ever watch TV, courtroom TV, you'll see all of the evidence being presented and witnesses, and all sorts of things like that. None of that happened here. This was a motion for summary judgment, which just means that each side presented an argument, the lawyers got up, said some stuff. The other lawyers got up, they said some stuff. They presented all of their evidence in paper form, more or less, and then through oral arguments, and then it was decided based on summary judgment. So there was no trial here. There was no sit down presenting of the evidence and stuff. And what that means typically is when it's a summary judgment ruling, is that there's no dispute of the facts. Both sides kind of agree these are the facts. That wasn't really the case here. Both sides didn't agree entirely on the facts. There were some disputes as far as how does funding work? How does that work? But Judge Page determined that upon these 5 counts, there was no dispute of the fact, and she said, I'm just going to determine what the law here says about each of these things. So she ruled summary judgment. And then she actually put a stay on her own order. So as you know, all of you are still receiving your EdChoice scholarships this year, despite EdChoice being ruled unconstitutional. And that's because she understood that if her order had gone into effect, thousands, hundreds of thousands of students would have immediately lost their scholarships. They would have immediately been thrown into public schools, and there was no way the public school system was going to be able to handle that. So she stayed the order. She knew it was going to be appealed, and it has been appealed. So we're now currently moving from the trial court into the appellate court system. So like I said, that first trial court, that's usually where they're the fact finding. They present all the evidence, they determine all the facts, and then they make a ruling. Here, they just determined the facts just through paper methods, depositions, things like that. So now on the appeals court, it'll be, I'm not sure which appeals judge it's been assigned to yet, but there'll be one appeals court judge, I believe, that they will review all of Judge Page's ruling. The parties have the opportunity to present their oral arguments again. They will kind of re-litigate, re-argue all 5 of those points because all 5 points have been appealed. And then we'll get a new ruling, and it will either uphold the original ruling, maybe uphold 1 or 2 of those points, maybe reverse all of them. We're not really sure. We can kind of guess that because they're still in Franklin County, that it will likely be more or less the same ruling that we had at the trial court level. So after the appeals process is exhausted there to the appellate court, they will have one more opportunity to appeal to the Supreme Court, and that is pretty much certain to happen. No matter what the ruling is, whether it's in our favor or in the public school's favor, we can pretty much know that whichever side loses will appeal to the Supreme Court. However, the Supreme Court doesn't have to accept every single case that is appealed to it. They have their own discretion. They can say, yep, we want to take this case, or no, we don't want to take this case. There's a very good chance the Supreme Court is taking this case.
Yeah, I mean, it's a near certain
Yeah.
certainty that the Supreme
Yeah.
Court, because it's such an important, would have
And
significant effects on on Ohio.
And because it is a state constitutional issue, it's not just a small torts claim or car crash kind of claim. It's a state constitutional issue that needs to be decided. So the Supreme Court will take it, and then there is a small chance, if for whatever reason, whatever the Supreme Court decides, it could be appealed to the U.S. Supreme Court. However, that's pretty unlikely. It could happen, and then the U.S. Supreme Court likewise can choose which cases they want to hear, but not very likely, especially considering it's a state constitutional claim. But it could happen. It's not
Brent,
impossible.
what kind of timeline are we looking at for the appeals hearing and an eventual move to the Supreme Court?
Yep. So right now, the parties have each submitted their initial briefs to say, this is what we decided, this is what we decided, here's our arguments. And now they're arguing against each other's briefs. So they've each submitted one brief, and I think today their reply briefs were due. So now they'll say, here's why the other side is wrong. And then I believe after that, the appellate judge will set that all up for in-person oral arguments. And we don't know for sure when that will happen. We're thinking sometime in the spring, March or so, sometime around there, we would assume. And then sometime after that, hopefully not too long after that, another month or so, maybe more, maybe less, sometime this summer, I would guess we would expect to know what that ruling is from the appellate side. And
So
then,
the appeals court would rule this summer, possibly. An appeal to the Supreme Court might take another 12 months in order to get
yep,
a ruling from the Supreme Court.
yep.
So we
And
could be looking into middle of 2020 or even late 2027.
that's right.
Okay.
And the one other way that there could be some sort of legal change here is if the legislature makes any sorts of changes to EdChoice. That would be a situation then where the Supreme Court says, hey, you guys need to, either submit new briefs or something like that to take in these new additional facts, which is what actually happened with the EdChoice expansion that was passed after the initial briefs were all submitted.
And one thing to note, while these appeals are being heard, the stay remains in place, right? So the
Mhm.
program continues to operate as it always has while these appeals are being heard. No one is at risk of losing their scholarship during the appeals process either, right? So if we could, Corinne, if we could go back and just look at these three accounts that Judge Page granted the plaintiffs, and maybe we can talk just a little bit about why we believe she ruled wrongly on these and why we believe the Supreme Court will overturn them. First of all, on the creation of one or more systems of common schools, while the state constitution directs the General Assembly to create a system of common schools, there is nothing that prohibits it from funding any other type of schools. Is that right?
That's right. Yep.
Yeah.
There could be, yep. They said, there's too many systems of schools, but there's nothing that says you can only have one. And
It's
there's
almost as
nothing
if
that
they're,
says how complex or complex the system might be. So you could say we have one system now. It's just many tentacles.
it's almost as if they are arguing that because the Constitution requires them to fund a system of common schools, they can't fund railroads, libraries, highways, or anything else, right? On number two, the second one, they said they failed to secure a thorough and efficient system of common schools. Was that entirely based on an argument that public schools are underfunded?
Pretty much, yeah, pretty much everything said, hey, the General Assembly didn't give us enough money, so why should you get any money at all?
We'll come back to that one because that one is the one that we find maybe most aggravating in the whole thing. On the third one, it unconstitutionally funds religious schools. One of the reasons they filed in state court, right, is because the federal courts have already ruled on this very issue multiple times. Is that right?
That's also true. Yep.
Can you talk about that?
Yeah, so the US Supreme Court has already determined that, money is going to parents here, things like that, that's all fine. And as long as all schools have access to the same funding, it's not an unconstitutional state funding of religious schools. In Ohio, Jewish schools get EdChoice, Catholic schools get EdChoice, any Christian school that wants to gets EdChoice. So there's no state funding of a
Or
specific
non-sectarian
religion.
schools, right?
Mhm. Yeah.
Non-sectarian schools
And
even.
schools, yep, schools that don't have any specific beliefs. Yep.
So it's interesting because the original case that the U.S. Supreme Court ruled on this was a case that originated here in Ohio that tested the constitutionality on First Amendment grounds of the Cleveland Scholarship. It was called the Zellman versus Ohio. It was in 2002. And the Supreme Court was very clear that this program did not violate the First Amendment and de facto did not fund religious schools because the money was going to parents and not to religious schools. It's sort of like arguing, what they're arguing is sort of like arguing that SNAP or WIC payments fund Kroger or Meijer, when intuitively, well, oh no, that money goes to families. It only incidentally ends up in the hands of a particular grocery store. The US Supreme Court ruled it's the same thing here. The state is not funding religious schools, they're funding parents. It's only incidental, it ends up in a religious school. For instance, if somebody wanted to use their SNAP payments to go purchase kosher or halal food, there would be no prohibition on that simply because it's religious in nature. It's the same idea here. We believe the court on all three of these counts that they granted are clearly wrong, and that's why we're so confident in winning and future courts, particularly at the Supreme Court level. Okay, let me just go through some quick talking points and some action points that you might have, and then we'll open it up for some questions. First of all, one thing to know, if you remember, the second claim that was granted was the claim that the state is not providing for a thorough and efficient system of common schools because they're underfunding them. This is a very important piece of information to know. Public school districts currently possess a combined $14 billion in cash reserves, and Ohio spends more than ever on public K-12 education. So what you hear in the media a lot is public schools claiming that the state has cut their budget and that the state is slashing the budget for public education. Please understand that is simply untrue. The state budget that was passed in 2025 provides more money, hundreds of millions of dollars more money for public K-12 education than any other budget, including the 2023 budget, the 2021 budget. It's simply not true. The fact that public school districts now possess $14 billion in cash reserves compared to 12 years ago. Just think of that, in 2013, right? The EdChoice participation rate was much smaller than it is now. In 2013, what you see is the participation in EdChoice really starting to increase significantly, particularly with the 2023 universal expansion. But it was going up even previously to that. Now, you would think if their argument was accurate, that EdChoice is draining money from public schools, you would think their cash position, their financial position would be increasingly worse over those 12 years. But what we see is the exact opposite. Their cash reserves, their collective cash reserves, have almost tripled during that same 12-year period, both in actual dollars. In 2013, their cash balances were $4.8 billion. So they've almost tripled there, both in real dollars and in terms relative to their annual expenditures, going from just under 20% of their annual expenditures to over 40% of their annual expenditures. So that's one of the reasons the General Assembly was on the verge of passing a bill that was going to say if districts are carrying huge cash reserves, they were going to have to refund some of that back to taxpayers. That bill ultimately didn't make it into the budget, but there was an awareness by General Assembly members that districts are sitting on massive amounts of cash. So that's one talking point to keep in mind. The second is this. This is data that was pulled directly from the Department of Education's website today, giving fiscal reports on per pupil revenue for each public school district. Now, remember, Columbus is the lead district in this suit. Columbus is receiving over $23,000 a year per student, and that is significantly up from just 5 years ago. This despite the fact that their enrollment is declining year over year. If you look at East Cleveland, they are one of the most incredible examples of this. Just last school year, East Cleveland, between state, local, and federal revenue, received over almost $48,000 per child. This notion that public schools are underfunded just does not match reality, and it certainly doesn't match the trend of school funding over the years. One thing to note about East Cleveland, they are now receiving $48,000 per student, despite the fact that their enrollment has dropped 30% over the last 4 years. So that claim just doesn't hold true. Particularly when you consider that the EdChoice scholarship is capped at $6,166 for a K-8 student or $8,408 for a high school student. And that's the highest award that a family can get. Many families are receiving even less than that. It's just not a valid argument that they're making. Another thing to keep in mind is that the coalition that is bringing suit is, again, I referenced it earlier, it's a coalition for adequacy and equity. And the way they operate and the way they're able to fund this lawsuit is by charging dues to public school districts that join the coalition. They charge $2 per student per year, plus some additional things. So they are collecting $2 million a year from public school districts in order to fund their lawsuit. Now, just think about the audacity of this. They are taking public tax dollars from public schools to fund a lawsuit to take away democratically enacted rights that Ohio taxpayers have been granted. It is an unbelievable model that they're doing. And that the fact that they're even able to do this is almost mind-boggling. I encourage you to find out if the district of your residence is actually one of these schools. You can find out by visiting their website, which is vouchershurtohio.com, and there they list their member institutions. If your district is on there, just know they are using your tax dollars to fund a lawsuit to take away a democratically elected right that you have been granted. I would encourage you to contact your local district and get many others who live there and vote on school levies in your district to contact your district and tell them you want them to leave this coalition. And if they are not on the list, call and thank them for that and tell them they should never think about joining, okay? Because they are actively recruiting additional districts to come into their fold. A second resource I want to show you, and I'm going to try and go to that now, is the website that I got that data from earlier about the per pupil spending. So if you go to reports.education.ohio.gov, you'll come to the Department of Education's website where all the financial data for public school districts are listed. You can go to, you find all kinds of things here, all kinds of data. But I'll just point out where I got the data about the cash balances and about some of the expenditures. You click on financial, you can go to this, you'll find this financial forecasts page. You click on that, you can go to cash balance analytics. And here's where you can find what your district's expenditures and cash balance analytics are for at least 5 years in the past. Okay, you'll come to this, choose traditional school districts, and then just go to choose a district and type in the district that you live in. Okay, I live in Westerville. I'll type in Westerville City and I'll pull up at least the last 5 years. So if I go back to the most recent year, I'll see that the total expenditures of Westerville City School District is just over $292 million. And they have $119 million in cash reserves. Okay, that represents almost 41% of their expenditures for the year they have in cash reserves. If you go back, scroll over here, you'll see a number of things. You'll see what total expenditures in previous years were, cash balances in previous years, and so forth. So I encourage you to go on to here and look at your district. For instance, if you live in Columbus City Schools, one of the things you can see is that they're sitting on $250 million in cash reserves. And yet, if you remember reading the Dispatch article just before the start of the school year, they had Columbus City School teachers that were bemoaning the fact that the district did not give them enough money to have pencils and paper in their classrooms. And yet the district is sitting on $250 million in cash reserves. This narrative that they are presenting, that they are grossly underfunded, just isn't true. And that's one thing that you're going to want to not only be aware of, but be able to speak to. So a couple things to keep in mind on other talking points. Elections matter, right? Who we vote into office, both in the General Assembly and in our court systems, matter. There will be a Supreme Court election this fall. That election is very important because we will be electing the very justices that will be hearing this case. I strongly recommend you do your due diligence on that election to determine who would be the best person to decide on this case. Right? And then lastly, I'll encourage you to be an advocate. I can tell you the public schools are mobilizing their families and their constituents to advocate against the EdChoice program. We are encouraging you to do the same thing. You don't have to know all the details. If you take some of the data that you heard tonight, maybe you do a little more digging, that's great. But the most important way you can be an advocate is to tell the story of how this program has benefited your child and your family, either by escaping a school that was poorly serving your family, or being able to go to a school that more closely aligned with your family's faith. Whatever that story is, tell it. Tell it to everybody. Put it on social media. Tell it to people at your church. Tell it to public school friends that you might know, to let them see the other side of the story. That is so critically important to do. And we strongly recommend you do that. And I'll share, I know one of the people on this webinar is Ann Riddle. Ann works with School Choice Ohio, and they are very good. They have a number of ways that you can get involved to help tell your story on that as well. You can see them at their website. I believe it's schoolchoiceohio.com. But that's kind of the big picture of the program. The most important thing that we hope you take away today is that the concern or anxiety that you are having about the future of this program, we want to ameliorate that fear. There's no need for you to have concern about the future of the program. This isn't a nothing thing. Of course, it's a lawsuit, but we strongly believe that this program is constitutional and that the Supreme Court will rule with finality, sometime in 2027 on its constitutionality, and the program will remain embedded for many, many years to come. We'll open it up for some questions now. If you have questions, you can either put it in the chat box or just unmute yourself. We'll go to the first one, the chat box. Did the lawsuit have an effect on the state not increasing the EdChoice awards even by the inflation rate? Do you anticipate the awards remaining the same in the next budget period? Actually, no, that really didn't have an effect. 2 years ago, we actually had a victory on that because for years, the actual EdChoice amount is what was passed year to year. So when the EdChoice amount was $4,500 at one point for elementary students, because that $4,500 was codified, it required an act of the General Assembly to increase it. And what happened was the General Assembly did, and so that amount stayed the same for 4 or 5 years at a time and never increased, which was a problem. The victory that we got 2 years ago was we convinced the General Assembly to peg the EdChoice amount to the increase that they're giving to the public school per pupil amount, okay? Because the General Assembly did not increase the base per pupil amount for public school students, the EdChoice amount remained the same. Now, keep in mind, I told you they're spending more this year on public education. That's because they are putting several $100 million into other areas of public school funding rather than the base amount. So they're getting more money, but that's why the EdChoice amount did not increase. We anticipate that amount going up in future budgets. So the state has a biennial budget every 2 years. The next one will be passed next summer, 2027. And we fully expect an increase in the amount to come in that budget. It comes in 2-year cycles. So it won't go up for 26, 27, but we expect for the 27, 28 school year to do that. What is funding our organization to finance this lawsuit? I'm not completely sure what that question means because we aren't financing a lawsuit. We're not party to the lawsuit. So we don't have any expenditures on the lawsuit. Any other questions?
I answered a handful of them in here already, so if anybody has additional questions about my answers to your original questions, feel free to pop those on there. I think you guys can read through those a little bit if you haven't yet.
Okay, well, what we'll do is we'll stick around. Corinne and I will stick around here for as long as there are people remaining on the call. But again, thank you for joining us tonight. Ohio's given us an incredible opportunity to place students into schools of their choice. And in our case, we believe strongly in the value of Christian education and the importance of the state providing students alternatives like that to its students. So we love the EdChoice program. We will always be an advocate for it, and we'll always be an advocate for you guys. So we'll stick around. If there are any questions, just go ahead and unmute yourself or type it in. If not, thank you for joining tonight and enjoy the rest of your evening.
There was a couple questions, and I answered this one earlier about whether or not the stay would need to be extended by the appellate court. Technically, yes, the appellate court will also have to issue a stay, which they're likely to do so because of the appealability, likelihood of appeal. If for some reason they did not issue a stay, Attorney General Yost can file for an emergency stay of the order, and then that would likely be. So there's additional avenues for getting a stay. So I do not anticipate that no matter what the ruling is from the appellate level, everything should still be functional until the Supreme Court.
Even Judge Page realized it would be far too disruptive not to have a stay during the appeals process. So the possibility that the stay is taken away is next to nil.
A couple people have questions about the website again for those reports. It's reports.education.ohio.gov.
Correct. If EdChoice is not voted constitutional, as I know you expect it to go through, will the traditional program remain or will the whole program go away? Again, I would say that we don't think that it's likely that either of those scenarios happen. But that could be, it could be possible that the judge only rule the expansion program as unconstitutional, allow the traditional to remain in place, or they could rule both of them unconstitutional and throw them both out. So that would really depend on the judge's ruling. Although again, we don't believe that's going to be the ultimate result.
And the original Cleveland Scholarship Program, which is more akin to the traditional program, but specifically for Cleveland, that program's actually been ruled constitutional several times already. So we would expect that that and traditional ed choice would remain at minimum. But we, like we said, we expect everything to stay as is.
Is there anything about EdChoice that prevents a school from increasing the tuition? So there's nothing in the legislation that prevents that. It's the market forces that are going to prevent that. And there's plenty of research that shows that school choice programs are not inflationary when it comes to private school tuition. Jeff Peterson, yes, the EdChoice amount will stay the same for the 26-27 school year. That's what was authorized in the biennial budget in 2025. So keep in mind, whatever is authorized in a 2-year budget remains there for 2 years. So the next budget will be in the summer, in June of 2027, and that will go into effect for the 27-28 school year. So more questions about tuition. We don't track private school tuition rates. So again, the factor that's the downward pressure on tuition are market forces. So I would say if a school that's the advantage of school choice programs, right? It creates an open marketplace for schools that allows parents to shop around, and that's what we would encourage all families to do. Obviously, we love Christian education and would support choices there. But even with Christian education, there are typically multiple options within a geographic area, and we think the market forces take care of that.
There's a question about the segregation claim and how they argue that there's not segregation when Christian education is increasing in tuition costs. And that's so the segregation claim is, I mean, it has to do with race, so it doesn't really have anything to do with the constitutionality of the EdChoice program. And we have definitive data actually out of Ohio State University that implementing EdChoice expansion has actually increased access to students of all races. So now, poor low-income students are just as capable of now accessing Christian education as wealthy students, no matter their race or anything else.
Yeah, there's a very interesting study by Dr. Stefan Levertu at Ohio State who looks specifically at the EdChoice program. It can be found on Fordham Institute's website. If you go to just search for Fordham Institute and look under their Ohio research link, it was again, came out a year or two ago. Again, it was Dr. Stefan Levertu, and he actually debunked a number of myths that the coalition is making, is claiming. One of them being this idea that EdChoice increases racial segregation, when in fact it was just the opposite. It provides more opportunities for those students to get a private education. Okay, well, if there are no other questions, we'll close this out. Again, thank you for joining us tonight. We appreciate it. Have a great evening, everybody.